SP Group's offer for separation via pro-rata distribution of shares and assets of the Tata Group. SP Group had proposed a division so that 80% share in all Tata Sons assets and companies would have gone to them. Appearing for the Tata Group, senior lawyer Harish Salve termed this offer for separation as nonsense, stating that the Palonji Group cannot seek any such relief. Salve argued that Mistry is seeking 80% stake in brand value as well, and how can he be rewarded for damaging the Tata brand? He submitted that the court can only ask Tata to buy out the minority stake at fair market value, and the offer for restructuring is akin to winding up of Tata Sons, which cannot be allowed at any cost. However, Salve argued that Palonji Group can be asked to cash out its holding and bow out when this deadlock has already continued between the two sides. The CJI had questioned that the resentment which was made to Ratan Tata's participation was initiated since he did not have any official authority, yet he was asking board members to discuss things in advance and asked Tata Sons Council to justify this question of demanding a decision by Ratan Tata, and asked what was the purpose of Ratan Tata's intervention, to which Salve had replied that all decisions needed an affirmative vote of majority nominees, and by virtue of being the chief trustee, Ratan Tata and the trust would have to be consulted in accordance with the Articles of Association. Salve also argued that the share value of Tata Motors would have tanked if decisions were shot down by the board and subsequently were reported in press, which would have led to bad coverage of the company. Salve also submitted that being outvoted does not amount to being oppressed, and referred to several statements which were made in the past about the Chorus deal and the Nano project, over which Mistry had objected to them, labeling them as loss-making ventures. Also, the CJI questioned the Mistry Group whether they had included details on their claims of lack of probity, which would be argued in due course by the Mistry Group. Also, it was submitted by Cyrus Investments that if Tata Sons had a role to play how companies function, they had a role on managing the board as well, since Tata Sons was controlling many companies. The CJI had asked Mistry's lawyer that which decisions did not go to the board despite trustees demanding the same. Also, the SP Group was asked to clarify whether they ever lost money without Tata Group losing money. Also, the CJI made it clear that whatever relief is being sought by Cyrus Mistry and the SP Group will have to remain within the four walls of Tata Sons. And also the CJI referred to the fact that Mistry had gone to court alleging operation by Tata Sons and not by TCS, Tata Teleservices or any other group companies. The CJI also raised a question which would of course be taken up even in future dates of hearing, whether the operation was of such a degree and it would justify the winding up of any company.